The U.S. Supreme Court today heard oral arguments in a gun rights case out of Texas.
A Texas man named Zaki Rahimi is challenging a federal law that bars anyone subject to a domestic violence restraining order from possessing a gun, arguing it's a violation of his Second Amendment rights.
And joining us now to discuss the legal concepts behind the case is Quinnipiac law professor Stephen Gilles. And Professor, we appreciate your time. Let me dive right in. This law is designed to protect domestic violence victims. How will the justices weigh that intent of the law against individual constitutional rights to bear arms?
Well, this law actually has two parts. Part one is if the judge says, look, this guy is a credible threat to his girlfriend or partner, then it becomes automatically a federal felony for that guy to hang on to his gun, to continue to possess a gun. Part two is if the state court judge in this civil proceeding says, I'm not going to make that finding about a credible threat, but I'm just going to tell him, you stay away from her, no physical violence, no threats of violence. Once again, it automatically becomes a federal felony for him to continue to possess a gun during the duration of that restraining order. Now, what's the court going to do with this? Today at the oral argument, it looked pretty clear that as to part one, the court would probably say, look, there's kind of a finding of dangerousness here, certainly to the partner and maybe to the public, and that might be enough for it to be constitutional to temporarily disarm this person, the guy, right, for the duration of the restraining order. Part two, though, is much broader because the judge is just basically saying, don't be violent. There's no finding that he's violent. The court, in my view, the court may strike that down, or they may say, we will decide that in a subsequent case because this guy, Rahimi, the judge made both findings. I think you're going to be violent and don't be violent. And Rahimi went out and proceeded to wave his gun at other people after that. So the court may rule narrowly.
Yeah, Professor Gilles, now I read in the advance information that we got from the university there, you have a feeling that they might well strike down parts of this law.
I think the part which simply says, if the judge says, I'm going to restrain either or both of the people in this relationship from using any force or threatening force against one another, that is a very thin basis for saying that the person, both those people, would be completely disarmed for the duration of the restraining order. The judge, in other words, the federal law doesn't say you can't use your gun anywhere near your partner. The federal law says if this guy Rahimi had just kept his gun in his bedroom drawer and never took it out, he would be breaking federal law. He would be a felon. He would be subject to a prison sentence of up to 15 years. That, I think, is the part where the court may say, Congress just went overboard there because there was no finding that he was dangerous.
Now, if that happens, what does this mean for lawmakers in keeping guns out of the hands of domestic abusers?
Well, I think there's quite a few things that states could do. They could increase the penalties for violating domestic orders. Another one they could do is they could say, and Congress could probably do this too, they could say, if somebody who's subject to a domestic violence restraining order violates it in a way that involves using a gun, extra penalties. But again, there we have an actual violation. Here, you can become a felon without committing a crime, without committing any other crime, right? If you just by possessing a gun.
Interesting. All right. Well, thank you.
My pleasure.
Yes, this is Stephen Gilles from Quinnipiac. We appreciate your time.